Recording in progress.
Oh, good afternoon, everyone. This is the time and place for a review hearing in the matter of Justin J. Coleman, Idaho State Bar Complaint 25-169A. This is a continued hearing from the hearing on January 6, 2026. The hearing has been being conducted pursuant to the Idaho Bar Commission Rule 509, subsection D. And this proceeding is being recorded by Madam Clerk. First, we'll identify all the parties in the line like we did in the last hearing. I'll start. I'm Alicia Moss. I'm the chair of the hearing committee. And Mr. Stefanik, can you go next, please?
Yes, Mike Stefanik, attorney for the committee. Yep.
Oh, sorry. Then Mr. Jacobson?
Hello, Soren Jacobson. I am a lay member of the committee.
And Mr. Schweitzer?
My name is Mr. Corey Schweitzer, and I am the grievant.
And Mr. Coleman?
Yes, Justin Coleman. I am a prosecuting attorney for Nez Perce County.
Okay, thank you. I don't see anyone else on our hearing except Madam Clerk. The grievant, Mr. Schweitzer, has requested this hearing for the purposes of reviewing Bar Counsel's May 29, 2025 disposition and decision finding that Mr. Schweitzer had not met his clear and convincing burden of proof that Attorney Coleman violated any rules of professional conduct. Previously, the committee had been provided with the written record of this matter, and specifically at the last hearing, we had been provided with a set of documents Bates numbered 1 through 225, which was the initial submission, and then a supplemental submission that was Bates stamp page numbers 1 through 1478, which was a supplemental. We have added some items to the record, and now the supplemental record consists of Bates stamp pages 1 through 1551. In that record, it generally consists of the initial complaint filed on April 21st of 2025, which was also amended, the correspondence to and from Bar Counsel with the parties, the Bar Counsel's May 29, 2025 disposition, and Mr. Schweitzer's request for a review. We also have two other pieces of evidence that were submitted and at this point are not admitted into the record and were denied admission to the record. The first one is the Coleman response, we're calling that, and then the second one was the Schweitzer rebuttal. Now, we do have an order from the committee denying the entry of those two items into the record. However, I do want to revisit that because, again, in the abundance of caution and just making sure we have a complete record, and at the same time weighing the efficiency of this and that it cannot go on forever and we cannot continue to accept documents, if I can get Mr. Schweitzer and Mr. Coleman to agree that these two items can come in without objection from either party, the committee has agreed to admit them. And I'd like to hear that on the record. I will start with Mr. Coleman because it was your response first. Would you object to Mr. Schweitzer's rebuttal to your response if we allowed your response in?
Excuse me, sorry, Madam Chair, I have no objection to that. I'd be fine with that.
Okay, great, thank you. And then I'll move on to Mr. Schweitzer. If we allow your rebuttal, Mr. Schweitzer, would you have any objection to Mr. Coleman's response coming in?
No.
Okay, great. So that's clear on the record, and we will allow those two items into the record. However, the record will be completely closed. This is an exception to our already previously closed record, and we will not be admitting any additional evidence into the record after this hearing.
I raise an objection to that. As you would like to continue, I will hold on my objection till my part.
And so noted, Mr. Schweitzer. We will continue to note your objection to that. So now, based on our discussion now, I will close the written record, and the committee will review this written record in rendering its final decision. So we'll go over the procedure for today's hearing. Mr. Schweitzer goes first and will present his arguments and his testimony about the evidence that has been admitted to the record and anything else that Mr. Schweitzer wants the committee to consider. He will have 15 minutes to do this presentation. I will note there was a motion to allow more time, and that was denied. And Mr. Schweitzer, we do note your continuing objection to that. Then we will give Mr. Coleman a chance to respond and present any argument or testimony, and he will also get 15 minutes. And I'd like to note that Mr. Coleman also asked for the presentation to be limited to 5 minutes, and that has already been ruled on and denied. And I will just note, Mr. Coleman, your objection for that record, our record. Then, if Mr. Coleman uses any time of his 15 minutes, then Mr. Schweitzer will have an additional 5 minutes for rebuttal. However, if Mr. Coleman does not use any of his 15 minutes, Mr. Schweitzer will not have a rebuttal, and we will be done with the testimony. I do like to put people under oath if you think either of you will be actually testifying to something that you believe is true and you want to be under oath testifying rather than just arguments. I'll start with Mr. Schweitzer. Do you feel like you will be testifying today?
I will be testifying under oath today. I swear to tell the
Wonderful.
truth, the whole truth, and nothing but the truth.
Okay, and Madam Clerk will swear you in when that's time. Mr. Coleman, do you think you will be testifying or only presenting argument?
Madam Chair, my intention is to just, it would just be argument, but I don't think, with the ruling to allow my response into the record, I don't know that I will have anything to add.
Okay. Okay, wonderful. So, Madam Clerk, can you go ahead and swear Mr. Schweitzer in only, please?
Yes. Corey Schweitzer, please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I swear to tell nothing but the truth, the whole truth, and nothing but the truth.
Thank you.
Okay, great. Thank you, Madam Clerk. I appreciate that. And of course, I reminded everyone at the last hearing, but I'll remind everybody again, the committee may have questions for you during your presentation. You might hear an interruption and for that question, but generally we like to save our questions to the end of the presentation, but just for a heads up, just in case we do ask any in the middle of your testimony or argument. I do want to also point out, as I did at the last hearing, that we will review the documents, the evidence, the arguments, all of the items that have already been submitted and included in the record, and you do not have to read from them. You do not have to do those things because we will review it. We would also appreciate if you want to point to something in the record. Please give us a Bates stamp page number to where we can refer to. It is a very voluminous record, and it would help the committee a lot if you could let us know which we should be looking during your argument or testimony. Does anybody have any questions about that procedure today? Again, noting the objections already noted, just any questions about it?
No, ma'am, I have no questions until I raise my objections.
Okay, so thank you very much. Oh, go ahead. Sorry.
This is Soren. I just have one question. As far as procedurally, if there are questions during somebody's testimony, does that quote unquote stop the clock, or is that taking up part of that 15 minutes?
Oh, thank you, Soren, for bringing that up. I appreciate that. We are going to be very flexible as a committee, that if we're asking a lot of questions and it's taking up a lot of time, we will use the time we need to get our questions answered, even if that goes past 15 minutes. But it will not be necessarily, another 30 minutes after. It will only just be to wrap up our questions. And so the clock won't necessarily stop, but I want to make sure the committee does get all its questions answered.
Okay, thank you.
Okay, great. Thank you again. Okay, so what I do, then I have a timer that I keep on my phone. So I'm going to bring that up, and then Mr. Schweitzer, you're going to go first, and I will let you know when the timer starts.
Thank you.
Right before I click it, yes. And then let me get my 15 minutes up here. And you may not hear it go off, but I'll let you know when it does go off. And again, like Mr. Jacobson asked, if we're in the middle of asking questions, we need extra questions, we will allow more time for our questions. Okay, and you, Mr. Schweitzer, you may.
I may begin? Thank you. Well, before I begin, I formally renew all of my prior procedural objections for this record. The motion for mistrial due to ex parte communications administered by Clerk Carlisle for this hearing is the same person that did the rush-through directive on the January 15th, 2026 by Chairperson Wessenberg to the community member that likewise taints this hearing. The motion for stay and the consolidation of cases 25-16A, the 25-169A, and 25-187A. That is for Justin Coleman's subordinate, April Smith, and his previous attorney of record for this hearing, Trey Turner. And of course, my objection to the exclusion of material evidence from the appeal record, namely the evidence submitted with Sue Ann Myers, who happens to be a witness also facing the same type of harassment from Justin Coleman. I will now present a corrected evidence-based chronology. I will speak for approximately 6 minutes, followed by one question from me to each hearing member, and if I'm interrupted out of turn, I will treat this as that confirmation of that procedural bias I'm alleging. I have autism, and in order for me to assist this hearing, I must first ask you to hold your questions until after my initial 6-minute statement and after each question that I have for each committee member. Before continuing, I'm asking again, may I please begin uninterrupted? The chronology. So in phase 1 in early 2020, I was assaulted at work at Traveland RV. All of these things are in the record already, but I wanted to go through the chronology of the events. In early 2021, I witnessed Traveland RV owner Tim Kruger bribing it was actually between 3 periods of October and January of 2021 that I watched Tim Kruger giving cash bribes to 2 police officers and 1 detective. And after reporting embezzlement, tax fraud, and internally, I was terminated. I reported this assault, bribery, and tax fraud to Lewiston PD in case 21L4897, but that was disregarded and primarily focused on the assault charge, which then was summarily dismissed by April Smith and the Nez Perce County Prosecutor's Office. Both agencies engaged in a circular refusal to act. Traveland RV, represented by Trey Turner, sued me for defamation on basis that I stated Traveland RV assaults veterans, based on the statement made online by Puccini. The argument made by Turner is that Puccini no longer worked or was employed by Traveland RV. In spring 23, I posted about the bribery on social media, namely Prosecutor Justin Coleman's page for the Nez Perce County Prosecutor's Office, and they blocked me on that Facebook page, a state action retaliation. At some unknown date, Trey Turner married Callie Jo Parker, a deputy prosecutor within Justin Coleman's office, and part of the evidence that I asked to be submitted to the record. In July 2023, Coleman became aware of the defamation judgment against me and claimed that I posted illicit images of Turner's client, Vittoria Puccini, online on the Nez Perce County Prosecutor's page. Instead of prosecuting me in Idaho, his jurisdiction, Justin Coleman is a prosecutor, he then turned that alleged evidence over to Trey Turner, who filed the police report in Clarkston, Washington. This is not a prosecutorial dereliction of duty. If Coleman believed that a crime truly occurred, it was his duty to prosecute, not outsource that retaliation to a private attorney married to one of Coleman's subordinates. In April 25 this year, I filed my Idaho State Bar grievance against Justin Coleman, April Smith for their dereliction of duty and failure to supervise respectively. In spring 2025, Coleman hired Trey Turner, the husband of his deputy prosecutor Parker, to defend him against my bar complaint. I filed additional bar grievances against Trey Turner alleging obstruction and conflicts of interest. In August 25, the ISB scheduled hearings despite documented conflicts and my stated unavailability with the request of Turner. In September of 25, I filed petitions for extraordinary writs. citing this structural bias. The hearing committee chair Alicia Moss initiated an ex parte meeting with community advocate Soren Jacobson during our last meeting. A bar commissioner was overheard telling the committee on January 15th to rush through that hearing. The ISB has closed the record and excluded my rebuttal evidence, including that previous letter as admitted by Karen Carlisle, and now only admitted during this hearing today. And part of that record that was denied was the ISB closed the record having to do with a letter from Police Chief Kuzik stating that no file was ever sent to Coleman's office to be denied. The IRS forms showing Hannah Lidkey's self-dealing. Now this is also before Coleman's office, Hannah Lidkey being a Nez Perce County commissioner and formerly the city council president, had been self-dealing taxpayer money to her nonprofit and then collecting a salary of $89,120 if we're being accurate. And as far as the parallel corruption over in Washington state, I filed a writ of mandamus for the same reason against Judge Brooke Burns for blocking me on Facebook for reporting this same police department bribery. And now I filed a Washington state auditor complaint and uncovered Hannah Lidkey's $350,000 self-dealing grants for her to take $176,000, give or take a few dollars. All these motions for mistrial, stay, and consolidation and federal referral have since been denied by this hearing. So I have one question for Soren Jacobson, community advocate. On January 6, 2026, at approximately 2:18 p.m. Mountain Time, your time, did Chairman Alicia Moss initiate a private meeting with you for this hearing? Do you confirm that this request occurred?
So, Mr. Schweitzer, before...
Ms. Moss, I'm asking Soren Jacobson a question.
And Mr. Schweitzer, I've gone ahead and outlined what happened. We allowed you your time without interruption until your question, which is your request. The committee is not here to answer questions, and we're not under oath, and we're not here as witnesses. So we do not answer questions. We ask you questions and we listen to your presentation. So that's the way the hearing committee works. We're not part of any of the substantive parts of this.
And to the legal chair of the committee, if such a private meeting took place between the hearing chair and the community advocate before the hearing, would you agree that that constitutes an ex parte communication? And if I were to have a recording of such communication to present before the Idaho State Supreme Court, would this hearing then be null and void?
So again, we are not here to answer questions as the chair or as the committee members. That's just the way these hearings work. We're here to hear your evidence and your arguments and for your grievance, which you have the burden to go ahead and prove that. And we're going to review all your evidence, and we're here to listen to your arguments.
Yes, ma'am.
And committee individual members, we're not in a position to answer questions. We're not party to this, and we're not under oath.
No, ma'am. But I am alleging that there was an ex parte communication. This hearing is a culmination.
That'll be on the record.
Yes, ma'am.
That's on the record because it's recorded.
Yes, ma'am.
Okay, go ahead, Mr. Switzer.
This hearing is a culmination of a 5-year pattern of retaliation, obstruction, and procedural corruption. From Coleman's dereliction of duty to the ISB's ex parte communication and evidence suppression. This system is shielding itself. That's all I really have to say today. Does anybody have any questions for me?
Sorry. Mr. Jacobson or Mr. Stefanik, do you have any questions?
Yeah, I'll go through my notes.
Great. I'm sorry, you can proceed, Mr. Stefanik.
I understand. I'm going through my notes trying to see what questions I have. Bear with me.
Sure. Well, I'm just claiming that there's 4 key violations. There's a failure to supervise and investigate criminal allegations. That's IRPC 5.1. It's a willful ignorance of credible evidence of bribery and tax evasion. If not that, then we could say it's Trey Turner going over to Clarkston, Washington to file that report for Turner. Or for Coleman, as Coleman alleges that I had posted naked pictures of Vittoria Puccini. So if he's saying that what he did was lawful, he's lying. I mean, that's a willful ignorance of credible evidence. There's the retaliatory censorship and malicious prosecution. That's IRPC 8.4 subdivision D, abuse of official government social media to censor a critic, followed by utilization of a false police report. Or 3, knowing acquisition of an adversarial tainted attorney, IRPC 1.7, hiring Trey Turner, who just assisted in filing that retaliatory police report against me, created an incurable conflict. Or orchestrating or allowing obstruction of public records, IRPC 8.4-D, misusing attorney-client privilege, and a procedural delays to block lawful IRPA requests. I mean, each one of these, we can go right down the list.
Have you, I have a couple questions.
Sure.
First of all, I want to make sure I understand. You were never represented by Mr. Trey Turner?
Never.
Correct?
No, he was always my opposing counsel.
And you were never represented by Mr. Coleman, is that fair?
I have never been represented by Mr. Coleman, nor have I ever made a criminal appearance in Nez Perce County Court.
Have you ever, have you sought, for example, on your public records request, have you sought any remedies through the district court for the perceived failure to provide you information you deemed you were entitled to?
No, I haven't, because I can already show through demonstrable evidence that Justin Coleman himself has already assisted Trey Turner in filing these other charges. So I have no expectations that even bringing it to a district court would have any positive effect. I mean, he's a Nez Perce County prosecutor. Isn't he supposed to be the one upholding justice, not the one trying to obstruct it?
I think you answered my question. Have you submitted, or have you filed a complaint with the Idaho Tax Commission?
Yes.
Regarding your allegation?
Multiple, yes.
Did that occur?
What do you mean, did that occur?
When did you file a complaint with the Idaho Tax Commission regarding your allegations that there were tax issues that you were alleging?
With Travelland RV, I initially filed that approximately in November of 2021. It could have been late October of 2021, but I supplied all of that evidence originally to a Mr. Dennis Schatt, a criminal investigator within the Idaho Department of Revenue. And immediately they had found about a dozen, maybe as many as 16 counts of tax evasion by October of 2023, as well as several different up to 9, I believe, personally for Kevin Munsterman, owner of Travelland RV. And then after that, I was contacted by a Mariel Gates in the beginning of 2024, in which she asked me if I had any more evidence of Travelland RV's tax evasion, fraud, and forgery. And again, I gave her substantial evidence, which then I attempted to have enter into the record. Currently, I believe the count is at 34 counts of between the Idaho Tax, the Department of Revenue, and the Department of Labor. I don't know the exact statistics on it, but there are 34 of those, 8 of which are currently open today.
You obviously feel like your constitutional rights have been offended.
Yeah, obviously, yes, sir.
Have you filed any civil complaint?
Yes, I've
constitutional issues that you allege happened with respect to Mr. Coleman, and have you done that?
Besides here in this hearing, no.
Correct.
With the Idaho State Bar, not yet, no.
Not with the Idaho State Bar. Civil remedies that you may or may not be entitled to through either.
Not yet. Nope. This was my first avenue. Yes.
Okay.
Again, sir, I have no expectations that operating within the confines of Nez Perce County, I would receive any kind of outcome. I do believe it would be closed summarily, or they would find some form of procedural issue to have it closed. Also, I don't know if you knew this, but it's incredibly difficult to hire any lawyer, even if you did have money, in Lewiston. And I certainly tried. In fact, I've contacted everybody in Google, in the telephone books. There is no lawyer that will represent me there.
Right, but you're aware that you could be a pro se litigant.
Oh, of course, yes. I'm aware of those things, but again, I reiterate, I can already prove that the Nez Perce County Prosecutor's Office is incestuous. I have no expectations that any hearing that would be held there would be fair. Likewise, I have substantial evidence to suggest that this hearing today would not be, and so far 2/3 of them have not, resulting in a grievance against Karen Carlisle sent to the Idaho State Supreme Court as of yesterday.
Okay. That's all the questions that I have right now. I
Thank
might
you.
have other if something comes up. Thank you.
Oh, thank you, Mr. Stefanik. Mr. Jacobson, do you have any questions?
Just briefly, Mr. Schweitzer, I've read through the entire record. My wife appreciates you. She's had a lot more time to read lately. So I've been through the record. I've been through it a couple times now. I'm just wondering, because you've reiterated a lot of what's in your emails today.
Yes.
And I'm going to give you a little bit of a berth here. Would you like to walk through that record at all and connect some dots? I'm looking at...
It depends on which dots you'd like connected, sir. I mean...
Well, okay, so what we're charged with here is to find from you, or to receive from you, clear and convincing evidence that something happened.
Sure.
So bluntly, what I'm looking for is a chain of evidence, a sequence of events or pieces of evidence that leads directly to one of your, you've got IRPC 5.1 and 8.4D and 1.7 and 8.4D. Again,
Sure.
I've got all your stuff right in front of me here. I'm just wondering, because like I said, I've read through this record. I'm going to read through this record again.
Yep.
The difference in that next reading is going to be, I have a docent right now who can take me through this and tell me in your mind
Sure.
how these pieces connect.
Sure. Sure.
And I just want to know if you want to do that, because you had your 6 minutes. You didn't do that then, which is fine. You don't have to. But I just want to make sure you've got the opportunity.
You would like me
make that
to
evidentiary case.
to walk
If you want
through the where the smoking gun is.
Well, just the trail of evidence. Build the case, and you don't have to do it for all of it, but maybe just for one of these things.
Sure.
Just so I can see how these pieces come together for you, because I want to hear it from you.
Sure.
Because when I read it again, I'm going to read it through the lens of what you said. Does that make sense?
Sure. So let's talk about the retaliatory censorship. That one is probably the easiest one for me to walk anyone through. But, I mean, really, we could also say the knowing acquisition of a conflicted attorney and then the failure to withdraw that attorney. Let's do that one. How about? That's the easiest of all of them. So Trey Turner is Justin Coleman's friend. And Justin Coleman's response, he outlines that Trey Turner, he went to Trey Turner's wedding. So knowing this, having a previous relationship with Trey Turner, then securing him as a counsel for this hearing is the initial conflict of interest. But besides that, there has been no withdrawal from Coleman or Turner that has been supplemented to this record. That is a violation of Idaho Ethics Opinion 137, that both Turner and Coleman would need to seek withdrawal from a tribunal like this before withdrawing. So in the, let's see, would you like to go to a Bates stamp number instead and walk through it that way? So
however you'd like to do it is fine with me.
Sure. So on May 28th, 2025, Attorney Trey Turner emails the ISB that he ceased representing Mr. Coleman. That's on Bates record page 168. Okay, so then in the IPRA request and obstruction emails, it says on page 43, 44, 47, 48, 51 and 52, 55 and 56, each one of these, the first one, let's see here. I'm going to get to the right Bates number. I'm using a PDF on this here. One moment. Alright, sorry about that. My computer is running slow on me. So, let's see. Sorry about that, sir. One moment. So getting back to Coleman here, on page... I'm sorry, it's not loading for me at the moment. I'm having some computer issues.
It's okay. If you want to walk me through it without going to specific pages, that's okay. Like I said, I've been through this record a few times. So
yeah.
I know what you're referring to.
So, in the initial response for the IPR, or the public documents request from the Nez Perce County Sheriff's Office, the Nez Perce County Sheriff's Office then consulted Coleman and then responded that I have not released any records, and then gave a response that it was refused due to attorney-client privilege. Likewise, then, I was mailed a document from the Nez Perce County Prosecutor's Office, Nance Cicerelli, approximately on June 5th of 2025, stating the same thing, and that has also been included in the record. And then that changed again from there when it got sent to the Nez Perce County Commissioners, who are supposed to be in charge of that documentation, requesting a PDR of the email chain between Coleman and Turner. The Nez Perce County Prosecutor's Office then declined it, stating a $9,000, close to $8,753 and some odd cents, somewhere around that figure, to release that one document of Turner and Coleman. It proves that there was a conflict of interest. Otherwise, there would be no reason for Turner to then withdraw from Coleman. But likewise, there was no proper withdrawal in which Turner notified me before that time. So, timeline of events is that I watched all of this bribery, tax evasion, these other things happening. I report these things to Justin Coleman, who also has the Nez Perce County Nick Woods working for him in the detective office, one of the people I watched taking bribes. There is a duty to document and release. And as far as Coleman stating that he received and then declined any of the things sent from the LPD, the Lewiston Police Department, there is no record, as confirmed by Jason Kuzik, of that information ever being transferred to the Nez Perce County Prosecutor's Office to be declined. So that would then be false. Is there anything else I can answer for you? I'm not super great with the whole evidence, walking you through it, besides giving you the documentation. I'm autistic.
This was great. It's helpful for me. I've read your email,
yes,
but it's helpful for me just to walk through it with you. I get a better idea of how you're looking at it.
Right.
So that's helpful. Thank you.
Okay, Mr. Jacobson, did you have any other further questions, or need Mr. Schweitzer to point anything else out on the record?
No, I think I'm good. I took a little more
Oh, that's okay. Again, that's why I said at the beginning, and I'm glad you asked that question. Where we don't confine the 15 minutes when our questions are being asked, where we give a lot of leeway on the committee for us to ask questions, because it's very important for us to understand the record, and we have Mr. Schweitzer here, and that is exactly what we need, is through his lens, or Mr. Coleman, when we go through his record, to understand through his lens as well. My questions were very similar to Mr. Jacobson, so he did cover that. I just wanted a little bit of a walkthrough as well, or pointing out anything. Mr. Schweitzer, I will give you an opportunity. Is there anything in this record, that any Bates page numbers, if you can, and I know you said you're not necessarily that good at it, but that's okay. We have the whole record, and we will review it again. But I want to give you the opportunity, if you would like me just to say, hey, you should really look at this piece of evidence, even though I will look at everything, we all will. This is one that's really key. Please pay extra attention to that. Do you have any pieces of evidence in the record that you'd like to point me to?
Well, sure. I mean, the chronology is the key. The office denied citing the privilege on June 5th when challenged. Turner withdrew on May 28th, the day before that this hearing was closed for all 4 members on the 29th. This shows that the privilege claim was a shield, not a legitimate bar. Likewise, all of the complaints before the Idaho State Bar Association were closed on March 29th for Coleman, Smith, and Turner and Weeks, despite there was no qualitative investigation performed by Deanna Tollefson of the Idaho State Bar, as illustrated by lack of any Bates numbers to illustrate her investigation or lack thereof. It's just an abuse of attorney-client privilege. The privilege fosters a candid legal advice. It's not... I don't know where else to go from here. I've given you all the evidence I think I can. There's a substantial amount that was included in the Turner hearing that Alicia Moss declined to put into this hearing, squarely assuring that it's going to have a fractured outcome between all of these, especially as they declined to have it consolidated.
Okay, thank you. No, that's really helpful. I'll definitely have an eye towards that chronology. And so, with that, you could have another minute or so if you have any closing remarks. I think we're all done with our questions. I'll just check with Mr. Stefanik really quickly. Do you have any additional questions after our questions?
At this time.
Okay, great. So because we did not interrupt, but we did ask a lot of questions, and that took up your time. I want to give you a couple minutes if you needed that before I ask Mr. Coleman if he has any presentation.
No, I'm fine.
Okay, great. Mr. Coleman, would you like to use any of your 15 minutes?
With the admission of my written response, I don't really have anything that I would add besides that, and I just ask you to review that.
Okay, great. So because Mr. Coleman has not used any of his time, there is no rebuttal to be made, and we are going to close this hearing, and we've asked all our questions, and our record is now complete. So under the rules, we have 21 days to get our written decision out, and I do expect that we should be able to get it out in 21 days, and once we issue our decision, we provide it to Madam Clerk, and then she will serve the same decision on all the parties, just like any other decision has been served in the past. I really appreciate everybody's participation in today's hearing. I really appreciate the perspective we've gotten from you, Mr. Schweitzer, and walking us through some of this record. And we will be reviewing all of it. And thank you, Mr. Coleman, for your submissions. And I appreciate everybody's participation again. And that concludes today's hearing. Thank you so much.
Thank you.
Recording stopped.
Ms. Moss, did you want, I guess Mr. Stefanik hopped off. Did you want the hearing committee to convene now and discuss, or I guess we lost everybody. Okay. Ms. Moss is off also, so I am ending for all.